Assalamualaikum warahmatullahi wabarakatuh. This lecture is meant to cover the second lecture, which means it is continuation of the first lecture, where we discuss about coercion, one of the vitiating factors in contract law of contract 2. So we discuss about coercion, and we discuss about section 15, the scope and the cases. We discuss 2 cases. Okay, we have discussed Tag 1 as well as Nuri Asia. Okay, so for this part, which is continuation of first lecture, so this is to replace second lecture. Okay, we are going to discuss about section 73. Okay, we want to discuss what is the relationship between section 15 and section 73. Why, in the first place, why we need to discuss section 73? Because if you read the provision of section 73, you can see the term under coercion, okay, is mentioned in that particular section. But the question is that whether the word coercion in section 73, does it have the similar meaning to the scope of section 15, or to the meaning which is affects to section 15? Because section 15, there are 2 limbs, as far as section 15 is concerned. The plaintiff needs to prove the act amounts to coercion, by relating it with penal code, or maybe by proving to the court that the unlawful detention of property, either of these 2 ways. But for section 73, the question now whether we should relate 15 and 73 together, because 15 is very narrow, definition is narrow, and then more or less analysis says that it is obsolete, as far as application is concerned. So when we talk about 73, the answer lies in this particular case, right? In Chin Dambi Development and Tai Kim Chu 1988, the principle, the ratio here is that the court made it clear definition of coercion in section 15 should only apply for the purpose contained in section 14. Meaning that here we read 14 and 15 together, because section 14 specifically says so. They are interrelated. So section 73, no connection whatsoever. Okay, so 15 and 14, it does not apply to section 73. So the word coercion in section 73. So what's the meaning here? Okay, the court said that it should be given ordinary and general meaning of the word as it is. Okay, no need to relate with unlawful detention. No need to prove it is under penal code. Okay. So, because why? What's the reason? What's the reason of this finding by the court here? Because nothing in section 15 says that this particular scope is applicable throughout the act. So 73 stands on its own, despite the word under coercion is being used. No connection with section 15. Okay, let's have a look at the case of Chin Nambi here. What happened? So in Chin Dambi, plaintiff and the case went to appeal later. Okay, plaintiff and respondent here, they were, a number of them were purchasers of a house, and defendants or appellants here, they were construction company, which was the house developer. So the contract involved here is sale and purchase. So both parties, they entered into sale and purchase agreement to purchase a house at this amount, to 29,500 those days, 1988, the year. So later, the appellants, the construction company, they asked for additional payment of 4,000, which is a big amount, from each plaintiff, each of the house buyer here. And the plaintiff agreed first, and later they brought the case to the court. They are asking for the additional payment that they have made. So respondent argued that when they paid this 4,000, it was paid under threat and coercion by director of the appellant company. They didn't want to pay, but they were under threat and coercion. And a magistrate court, the lower court held that yes, additional payment of 4,000 here, it was really an increase in the purchase price, and it was obtained by means of threat and coercion. So finding, the plaintiff won the case. So defendant was not happy. That's why they appeal. Appellants appeal against the decision, and the High Court here said that no good or sufficient cause to disturb the finding. Basically, High Court agreed with the finding by the magistrate court. Because why? From the facts of the case here, respondent, the house buyer, they have been threatened to do so on pain of having their bookings for the houses cancelled. In that here, they were threatened, okay, if you didn't pay this 4,000, we are going to cancel your booking. So that's why they paid. But later, they brought the case to the court. They're asking for a refund of this 4,000. And then another rule or observation from the court here, the court made it clear. The court interpreted section 73. The court said that the word coercion in the context of 73 should be given ordinary and general meaning, because nothing under section 15 which says coercion must apply throughout the act. The meaning of 15 here must be applicable throughout the act. Nothing. So that's why the court said, well, we just give the normal meaning. Threat, coercion, compulsion, whatsoever. Nothing to do with unlawful detention. Nothing to do with the act under penal code. So the court finally ordered that the amounts paid by the respondent, by the house buyer, must be refunded, because 73 said, made it clear, it relates to remedy actually, in relation to the act of coercion, under coercion here, under 73 of Contracts Act. You can read the actual provisions later. Okay, now the second part, the next part of the topic is about duress and economic duress. But you cannot see this term under Contracts Act, because Contracts Act we use the term coercion, and this is the term actually you can find it under English law. So what is duress at common law? So actually even under common law, the scope of duress was very narrow. Initially, in the previous position, the scope of duress here, it was confined to unlawful physical violence. So very specific, only physical violence to the person or constraint of the other party. Doesn't matter whether it's actual or threatened, but it must involve unlawful physical violence. So it's very narrow. And then the court in the past, they have been refusing to recognize duress of goods, because nothing to do with physical violence for duress of goods. This is about the goods. So they said, no, it cannot invalidate a contract. This is the earlier or previous position. But modern cases later, they have a more flexible approach, because from the cases, we can see that the court, from the cases, it is reflected that coercion of the will is the essence. We will see whether the victim was under coercion of the will or not. So if we refer to title, the one of the law textbook, contract law textbook. So the question in each case should be whether there had been in fact coercion of the will. So it doesn't matter how it happened, whether it relates to goods, whether it relates to physical, So, but then whether it amounts to coercion of the will or not. Remember, we are still discussing the position at common law. So under common law, they have specific definition of economic duress. So when we talk about economic duress here, it refers to unacceptable commercial pressure. Commercial pressure is something which is inherent, but then in some situation, it is something which is unacceptable. And then another way of defining economic duress here, it refers to unfair use of a dominant bargaining position. So two parties, but then one party is dominant compared to the other. So in order for the court to recognize economic duress here, it requires imminent threat of economic loss. It has to be real, real threat here. So we have two cases actually to discuss economic duress. The leading case, in which the court made a finding in favor of the victim, where economic duress was being imposed. So the first case is Atlas Express Limited and CAFCO Limited, 1989. So in this case, why it is important? Okay, because economic duress was discussed by the court, and then the court laid down the rule. Okay, it was said that duress requires coercion of the will. Okay, so as to vitiate consent, so it make consent becomes weaken the consent, and that the court distinguish with mere commercial pressure. So mere commercial pressure is not sufficient. It has something which is, it has to be something which is more than that. But again, how do we draw a line between the two? Okay, between acceptable commercial pressure or something which is beyond that. Okay, so how to differentiate between unacceptable commercial pressure? Okay, and in that case, it will attract intervention of the law. The law will come over to assist. But in some other situation, it's just normal, mere commercial pressure. Okay, it's just an ordinary rough and tumble of the marketplace. Okay, at the moment you decided to be in the business, so there are so many challenges, obviously. Okay, rough and tumble of the marketplace, and in that particular situation, okay, no help provided by the law. I mean, it's about you being competent, okay, to do. I mean, it's a stiff competition, okay, in the marketplace. So the dividing line, okay, between the two will always be difficult to draw. It's not that easy. Okay, cannot simply draw. Okay, and what is the consideration here? It may depend upon a close examination of facts, okay, of particular case. It depends very much on the facts. Okay, so it might vary from one situation to another. Okay, we go back to Atlas. We want to know what's the facts between Atlas and Kefco here. So Kefco is a small company dealing in basketwear, okay, like the picture. And Atlas was a national road carrier. I think in Malaysia, our national road carrier is Pos Laju, okay. But we also have some other companies, but really not national road carrier. So Kefco, this small company, small basketwear company, the company has secured a large contract from Woolworth. Okay, Woolworth is a retail company. Like in Malaysia, we have Aeon. Okay, but Aeon not really local, kan? But still, I mean, that's an example. Okay, Woolworth, and had obtained a large quantity of goods to fulfill it. So this small company got a big contract from Woolworth, and then to serve this contract, okay, Kefco entered into another contract with Atlas, okay, the national road carrier here. To do what? To distribute the goods to Woolworth shops. Okay, I mean, to do the transportation, basically the delivery. So before they enter into the contract, Atlas manager inspected the cartoons used by Kefco, and he made some estimation, okay, of the price here. So he said, well, in my estimation, a minimum load of 400 cartons, okay. So I mean, this is the minimum. He made the estimation. So he quoted the price of 110, okay, here, and total will be times by 400, then it will be 440 pound. Okay, so that's the quotation. This is in the year, what year? Kefco, 1989. Okay, but actual delivery later, okay, the first load contain only half, all right, not 400, 200 only, okay. So manager said, well, this is not practical because we thought you are delivering 400. So now, Atlas said, you must pay. I mean, you must deliver minimum of 140. Otherwise, we don't want to deliver, okay, your stuff here, right? So that's what Atlas said to Kefco. And Kefco agreed, but later they brought this case to the court lah, basically, all right? So Kefco said, well, we agreed because of this reason. Okay, we were being under coercion, under economic duress. Okay, that's an argument by Kefco in the court. They said we agreed because we must meet the delivery dates, okay, for us to survive. We are just a small company, and it's very hard for us to find alternative carriers. And then that's why, okay, we agreed to the new term, but later they refused to pay. Okay, they wanted to pay only half of it. So that's why we have this case lah. They brought their dispute to the court. So the court said that the court was give judgment in favor of the small company Kefco, because even in who was in the dominant bargaining position here? Atlas, because they are the national, they were the national carrier. So the court held that CAFCO were not bound by the new terms, okay? And then in this case, yes, economic duress had vitiated the new agreement, okay? And in any case, there was no consideration, as if there were two contracts here. First with the estimation of the price, okay, and later actual delivery. So I mean, when Atlas asked for a new price, so I mean there's no consideration for it. That's what the court said. And the judge, Tucker J, he held that defendant's apparent consent to the agreement, okay, when defendant consent to it, he was being induced by pressure, which was illegitimate. Okay, and then it was not approbated. It shouldn't be approved. Okay. In other words, big companies shouldn't bully the small company, okay, the bottom line or the hidden message. Okay, another case relating to economic duress. This is 1983, judgment by House of Lords. Universe Tankship Incorporation of Monrovia and International Transport Workers Federation. So it's a ship against the union, actually, workers union, workers federation here. So International Transport Workers Federation, they black the claimant ship. Okay, they black lah, they mark, okay, they mark the claimant ship and they prevent them, okay, the ship from leaving dock unless the ship, the owner, okay, of the ship sign a new contract for their employees, asking for more benefit, more payment whatsoever. And later this ship, okay, they disputed lah, despite that they agreed, but actually they didn't agree. They were under commercial pressure. That's what they said. Okay, so the court, the issue is here is, had the new contracts, okay, had been signed under duress. Was it signed under duress? Okay, that's the issue. And the court held that yes, it was. Okay, contracts were void, and the court also made some observation. Okay, the court said that with regards to what is acceptable pressure and what is not, okay, the court will look to the nature of the pressure, okay, the means used, okay, the demand being made, and the end sought. So if all were answered in affirmative, then there was economic duress. So in this case, yes, okay, there was. The contract was being signed under commercial pressure, illegitimate. Okay, what is the current position of duress in England? We want to know the latest position. Okay, again, in reality, actually, it's difficult, okay, to succeed upon a plea of duress. If the party file a case under duress, it's hard to win the case. Again, there are not many cases for duress or economic duress as compared to cases of undue influence. We are going to learn, okay, in the second topic later. And as far as common law is concerned, they also have courts of equity, rules of equity, courts of equity, court which enforce equity. So intervention of equity by the wider doctrine of undue influence has diminished the importance of duress. I mean that here the party has preference, okay, preferable to file a case or to bring the case under undue influence compared to under duress here. Okay. Now we want to know what is the position of economic duress in Malaysia. Do we apply? Do we adopt? Do we follow? So actually, there's no yes or no rule answer here. Okay, it's unsettled. Because why? Okay, the reason is that economic duress is not part of Malaysian law. We cannot find any section under Contracts Act which is relevant to economic duress. It doesn't say, it doesn't mention at all. Okay, but still, okay, we have two approaches, and both cases here by High Court. So we don't, High Court, they are not bound. This High Court is not bound by another High Court. But if judgment by Court of Appeal, then High Court must follow. Okay, so we have two approaches here. First, it's not relevant. Another one might be relevant. Economic duress might be relevant to Malaysia, might be applicable. Okay, maybe we can apply. So we have place plantation. This is we call close the door concept. We close the door to economic duress. We don't want to apply economic duress in Malaysia. This is, the judgment in year 1988. But in the later case, Muhammad Farid Subramaniam, 1997, the court was more flexible. Okay, the court said, well, it could be applied if certain conditions are fulfilled. It's not really closed door. It's still possible. Okay, flexible approach here. So in other words, by way of analysis, actually it amounts to attempts to introduce economic duress in Malaysia by way of case law rather than by way of statute. We go to the case one by one. So in police plantation, this is a case reported in CLJ, Current Law Journal. So it is stated that the rule taken from this case, English common law relating to economic coercion does not apply in Malaysia. Why is that so? Because our Contracts Act, this is the observation by the court, our Contracts Act does not provide for any form of coercion other than as defined by Section 15. That's why, I mean, there's no room to apply economic duress in Malaysia. That's what the court said. And then as far as duress is concerned, if it is equivalent to coercion, then defendant must prove the case under Section 15. Prove it under the scope of Section 15. That's what the court said. Okay, and then when defendant brought the case to the court, the defendant didn't do it. Didn't try to apply, didn't try to fulfill the conditions, the requirement, scope of Section 15. Okay, and then that's why the court said clearly here, he does not make any accusation of the committing or threatening to commit any act forbidden by penal code, or nothing about detention of or threat to detain property. So it doesn't fall under scope of Section 15. So there's no way to apply economic duress in Malaysia. Okay, and this is the argument by the council. Okay, council said, well, look at England. Okay, it's possible to, to really prove that the parties' consent was not free. Okay, and then they have economic coercion over there. So and then the court English court allow contract, okay, which had been entered into by one party as a result of economic coercion. Okay, I mean, here contract can be invalidated by result of economic duress. But the court said, yes, we agreed that may be so. But as far as our Contracts Act is concerned, okay, it does not provide for any form of coercion other than as defined by Section 15. Okay, and that's it. It's like closed door approach or concept. No room, okay, to apply economic duress. So that one in year 1988. But later, another case decided by High Court in 1997, Muhammad Farid Subramaniam and Nazam Motor Trading. Here, plaintiff was appointed as one of the defendant's taxi driver, okay, and plaintiff must pay daily rental for the taxi. It's like daily rental, whatever amount here. And later, plaintiff failed to pay his daily rental, so defendant repossessed the taxi. Plaintiff filed a suit, okay, to challenge, okay, the act of the defendant, okay, for the return of the taxi. Taxi doesn't belong to him actually, okay. It was just the hirer, the one who ran, okay, the taxi. And one of the argument, okay, by the plaintiff was that when he signed the agreement, okay, for the hire, okay, of the taxi, rental of the taxi here, he signed the agreement under duress. He mentioned the word duress here. And when the court examined, okay, the argument further, the court said, well, okay, we can allow your plea or your argument here, your allegation here, but there are ways to do so. Okay, the court said there are some factors which the law could regard as coercion of the victim's will, so as to vitiate consent. So the court listed down at least four factors here to see whether the victim was under duress or not. Okay, first, whether the victim protest or did not protest, whether there's any alternative cause, whether there's any independent advice, whether the victim took steps to avoid it. Okay, if the answer are all in affirmative, then okay, yes, the court might agree there might be duress, okay, which vitiate consent. He must fulfill all the factors here. But then, okay, if we apply all the factors here, actually on the part of the plaintiff, no protest. Okay, he only protests later lah. All right, from the very beginning, he did not protest. Okay, of the repossession of the taxi here. Okay, no protest of any manner or form. Okay, either before or after the agreement. When he signed the agreement for the rental of the taxi, he did so with his full consent. Okay, only when repossession took place, only he protest. So it was too late. So I mean, that's the right of the owner of the taxi actually. Okay? And there was also no evidence adduced that he had taken any steps, okay, subsequently to repudiate this document. If he did sign a contract under coercion, then he has to avoid it, do something. Okay? Lodge a police report, for example, to show that he was really under duress here. And how the court actually managed to come up with these 4 factors here. The court referred to this case, referred to common law case, Pao On and Lau Yu Long. I think this is also a case judgment by House of Law, 1980. Okay, the last part of our topic is effects and remedies. So on top of section 10, 14, 15, 73, we also have section 19. 19 said clearly what happened to the contract affected because of coercion. The contract becomes voidable. Voidable means that here it's possible to proceed, make it valid, or it's possible to stop, make it void. And for definition of void contract, you can find it under interpretation section, section 2J. Okay, it talk about what is meant by void contract. And then on top of that, we also have section 66. Okay, the moment the contract, the party choose to invalidate the contract, okay, the one who complained, usually the victim. So it comes together with obligation. So 66 here, it talk about obligation of a person who has received advantages under void contract. I mean, he has to return because now the contract becomes void. So obligation of this person to usually to restore. We try to restore back the parties to their earlier position because what happened to contract? Contract cannot be enforced, it becomes void. Okay, remedy, this is the remedy. Okay, this is the effect. Okay, this is the remedy. So remedy here too. Okay, first rescission, we set aside. Okay, the parties are discharged from obligation under section 19, section 1 just now, and also restitution. Okay, restore. So we restore the party back to their earlier position. Okay, just now I said, okay, cross refer to 2JN 66. Also 65. 65, 66, usually they go together. It talk about void contract. And this is for your additional reading. Not really recent, but then because we don't have any amendment to the section 15 or 16, so the discussion or the views by these authors are still relevant if you want to know more. But it's quite lengthy if you read. Okay, it is beyond our syllabus or discussion, but then it gives you a broader view if you read. Okay, if you read these articles. Okay, I think that's all. Okay, I stop share. Okay, so we have completed the topic, the first topic of coercion. So we cover in 2 parts, lecture 1 and lecture 2. If you have any question, feel free to ask. Okay? Assalamualaikum warahmatullahi wabarakatuh.